Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. I will touch today upon the concept of control as applicable in sanctions law. Control can be said to be a twin brother of ownership criteria, which we discussed in the previous presentation, with the purpose being to define that scope of assets which fall within the restrictive application of the sanctions program. We would follow similarly same pattern which we followed when discussing the ownership concept, and we would discuss how control has autonomous meaning in sanctions law. Then we would briefly touch upon its applications in various jurisdictions and finish this presentation by way of discussing practical examples when control becomes relevant for the application of sanctions. Similar to ownership criteria, which we previously discussed, the purpose of control is to set the limits with respect to those assets which fall within the restrictive sanctions. To the extent the asset is controlled by a blocked person, that asset would be blocked. To the extent a company is controlled by a blocked person, even if the company itself is not listed in the relevant sanctions regimes, all the assets belonging to the company will be blocked because it's deemed that this controlled person can have access to those assets through the company. Whilst control has meaning and defined term in, for example, companies' laws, the courts, when applying this concept within the sanctions programs, will not be limited to those meaning and terms. So whilst certainly, if control is found as a matter of, for example, national company law, this would be strong indication that control is equally present for the purpose of the sanctions law. The reverse will not be the case, because when applying control for the purpose of sanctions legislations, the courts are following a very broad idea that any assets or any decisions which can be influenced by a person subject to the blocking sanctions may result in finding the control. From this perspective, the concept is very broad, and it's very difficult to set any clear boundaries for its application, as well as to say with certainty that a certain asset or a certain company is or is not controlled by a blocked person. This shall not be surprising for us, because at the end of the day, the national regimes today, which apply the concept of control for the purpose of their sanctions programs, borrow that concept from the UN multilateral sanctions regime, which were developed by the United Nations in the concept of very specific objectives set by the UN Security Council, meaning to oppose threats to peace and security. Given these objectives, it's quite clear that the UN Security Council would use the concept which is as broad as possible. Question remains, though, whether the same is adequate for national autonomous sanctions regimes, which often cover a much broader set of issues than the relevant multilateral sanctions regimes of the UN Security Council. And it may be for that reason that, for example, United States, as we will discuss later, are not using the concept of control for most of their sanctions programs. Here we look at one of the examples of how control is used in the EU sanctions regimes. This is standard wording, the first one introducing the so-called blocking sanctions with respect to individuals or companies, whereby all assets controlled by the relevant designated individual or company will need to be blocked. The concept of control is also present in sectoral sanctions, where typically It's narrower version of entity acting at the direction of, on behalf of a sanctioned person will be subject to the same sanctions. UK, who modeled their sanction regime on the EU sanctions, also use the concept of control, where we can see that control is defined as the ability to affect the result of the relevant person in significant respects. So again, a very, very broad definition of control, almost unlimited to the form in which it's achieved. Conversely, the US autonomous sanctions would be an example of a regime where the concept of control is not used for most of the sanctions program. The US regime is primarily based on the idea of listing the relevant persons in the relevant lists by name, and then applying ownership criteria to extend the scope of sanctions beyond those persons who are specifically listed. Again, in part, this potentially can be explained that it's very difficult, as we would see, to apply the concept of control in day-to-day complex transactions. Nevertheless, even in the United States, the control is not entirely without its place in the sanction programs. There are certain circumstances when the United States still use the concept of control, and where the concept used, it's used in a very, very broad term. We can see here, for example, with respect to the Iran financial sanctions regulations, the concept is used to define the scope of the transactions which are prohibited when the government of Iran or any person controlled is a party to those transactions. And we can see there that the definition of control is very wide, as it refers to any person which is otherwise controlled by the government, and no specific explanation is given to what is otherwise controlled means, meaning that the terms will be defined in its literal meaning and potentially can include any type of situation when one person can direct or change or affect the decisions of another person. A specific example of the US sanctions regimes where the transfer of the restrictions applicable to a blocked person to non-blocked person outside of the ownership concept may be a situation when the individual who is blocked is acting on behalf of a non-blocked company. And from the US perspective, although that individual certainly affects the transaction on behalf of the company, the US persons or any other persons working within the US jurisdiction cannot engage with such individual with respect to any transaction or any other matters which may have legal effect. So having briefly discussed the breadth of the concept, we would now consider how it can apply within and outside the corporate structures. Similar to ownership, we'll start with non-corporate structures, where it would be fair to say that any type of rights which a blocked person has with respect to the assets, being the rights based on the power of attorney, for example, granted with respect to the operation of accounts, or the rights granted to a, for example, blocked financial institution on the basis of discretionary portfolio management, and all the rights of the shareholders within the shareholders agreement or any other contracts can potentially result in finding control with respect to that asset, which may be subject to the arrangement where a blocked person is a part of. There is uncertainty as to how far the control can be interpreted. For example, if we take very extensive covenants in a loan agreement and the relationship between the borrower, let's assume the borrower is a non-blocked person, and the bank, which is subject to blocking sanctions. So would the covenants in the loan agreement create the control exercised by the sanctioned bank over the borrower with the view that the assets of the borrower are frozen? Given the definition of control, presumably many answers are possible in this situation. My personal view is that control shall not arise in the circumstances which I've just described, for the reason that the purpose of the sanctions is ultimately to in these circumstances affect the assets of the bank and not the assets of the borrowers, which are unrelated to the bank and which have just this type of arrangement with the bank. Furthermore, the loan agreement would typically not allow to enforce these type of covenants except by way of declaring an event of default and accelerating the debt, which by itself would not be permitted if the relevant bank is subject to the blocking sanctions. So all in all, this is not the type of arrangement which can be enforced by the borrower and accordingly give rise to the situation of control. But nevertheless, the argument to a certain extent is possible given the breadth of the definition of control itself. One point to mention with respect to control outside of corporate structures is that control is not automatically transferred from one individual to the other, as opposed from an individual to a company. So, for example, it's not automatically that the, for example, father of the family controls his children, regardless of whether they're minors or already attained the age of majority. So there is no automatic transfer of control in the context of individual relationship. Nevertheless, we would see that to the extent the assets are transferred in between close relatives, the relevant institutions have to pay attention whether the original person retained the control over those assets. The only EU regulation which really defines the control over a corporate structure is the Regulation 2580, which relates to restrictive measures with respect to combating terrorism. So again, the scope of the regulation is combating terrorism. Nevertheless, the relevant definitions proposed in this regulation for the purpose of control have been endorsed by the Council, for example, for the purpose of Russian sanctions regulations. And here from the definition, we can see the elements of control which are standard for a corporate structure, like the ability to appoint the majority of the decision-making bodies or exercising the majority of votes in the voting capital of the company. But there are importantly also the elements which relate to so-called de facto control, which we discussed, being the ability to affect, change, or dictate the decisions of the relevant entity without any kind of formal arrangements in place. So whilst the definition is helpful in the sense that to the extent any of the elements present there give a strong indication of control, the definition is certainly not supposed to be exhaustive, and as we see, introduces a mixture of legal and factual elements in the analysis. In addition to that definition, the EU best practices for the implementation of restrictive measures, as well as various guidances issued by the European Commission with respect to the application of restrictive measures within various sanctions programs, give us a couple of further examples which give indication that control may be retained over the relevant assets by the designated person. Few examples would be typically related to the situation when the designated person will formally transfer the ownership, but then would retain some kind of rights as to the retransfer of the ownership. This would be the buyback scenario structures, use of front persons, and this type of arrangements. But in addition to those, we have the situations when, as we discussed, the transfer of ownership will be made to a close relative or to a close business partner. And even in the absence of a formal legal arrangements for the retransfer, given the family or long business relationship, an issue arises if the transferor has or has not really transferred all interests in the relevant assets. This is, again, very often a factual question, difficult to answer in abstract, would require a careful analysis of how the company or the relevant group is managed in its day-to-day business operations, which may be very difficult to make from the perspective of a third-party operator, which other than public news and the information coming from the clients and companies themselves, can very rarely embark on a more in-depth investigation of the factual situation on the ground. With this in mind and taking into account high penalties which the operators would face if they inadequately identify the situation of control and do not comply with their obligations under the national sanctions regime, a question arises as to what the operators can do in practice to mitigate their risks. As I said, in certain jurisdictions, the matter was considered to be so vague and unpredictable in its application that the relevant sanctions authorities decided to avoid its application as a general matter. In those jurisdictions where the control concept is used, the regulator was also well aware of all those uncertainties which may arise in connection with the application of the concept. So one of the solutions proposed, for example, in the European Union was the certification of the firewalls, which purpose was to make the official declaration as to the presence or absence of control by the relevant individual or a company. The relevant guidance on the recognition and implementation of firewalls were published by the European Commission, but as with many of those procedures, given that their implementation is to be done at the national level and highly depends on the national legislator, an issue arises as to whether this can be effectively used throughout the European Union. Unfortunately, no certification procedure is available for the time being at the level of the European Union, which would have been administered by the European Commission or any of its departments, with a view to ensure that there is a uniform understanding whether one person is or is not controlled by a blocked individual. So whether firewalls will work, we would see going forward. And for the time being, the only other elements of control is to seek some sort of declaratory judgment or opinions from those courts which are allowed to issue judgments in accordance with the national procedural laws, which may not be always the case, as well as from national competent authorities to the extent they may be willing to do so. Certainly, all in all, it appears that the operators have very little effective mechanisms in place, and it's very difficult for them in the absence of proactive support from the relevant regulators to ensure whether one or the other situation results in control. Thank you very much for watching. I hope that you find this presentation useful and hope to see you going forward.